So, welcome to the League of Women Voters Wisconsin's second webinar on the Wisconsin Supreme Court election on April 1st. I'm Joan Schwartz, an attorney, a member of the board of the Wisconsin League of Women Voters, chair of the Impartial Justice Committee, which did excellent research and planning for this webinar. A big thank you to Kathy Annan, Jane Benson, John Callan, Myra Enlow, Cheryl Moranto, Janie Beebe, and Dorothy Skye for all their work. Please provide your comments and questions in the chat. There'll be a question and answer period at the end of the presentations. And of course, as usual, a recording of tonight's webinar will be available in a few days on the League website. Our first webinar on the Supreme Court election focused on money and politics and the need for an enforcement of a recusal rule that a Supreme Court justice must excuse him or herself if there is a conflict of interest, or even if there is the appearance of a conflict of interest. Recording of this webinar is on the League website, just that if you did not attend that webinar, you might want to review it. This webinar on the Supreme Court election is entitled Judging Judicial Candidates. We will be focusing on the state of our judiciary system today in our polarized environment, as well as discussing the differences between the positions, the two candidates who are circuit court judges versus the kinds of judgment needed to be a Supreme Court justice. Our state's highest court is crucial to the well-being of all Wisconsinites. State high courts interpret laws that impact some of the most intimate parts of our lives. Communities have a right to know what's on the docket, and it's our responsibilities as citizens and voters to carefully consider who sits on our state Supreme Court. I'm going to just interrupt. Delaney, can you put that on the speaker focus? That would be helpful. Oops. Okay, well, all right. Nearly 50 years ago, former Supreme Court Justice William Brennan Jr. observed that state courts, no less than federal, are and ought to be guardians of liberties. He was so right. More than 98% of court cases filed in the United States are filed in state courts. State courts play an outside role in certain areas of law, including cases that implicate core civil liberties, protect access to reproductive justice care post-Dobbs, LGBTQ+ rights, freedom of speech, voting rights, redistricting, and other more robust protection to people who have or could be subject to unreasonable searches and seizures. A state court's ability to guard our liberties depends in significant part on whether our courts adopt transparent processes that allow members of the public to learn about, monitor, and participate in important state court cases. For example, when state courts list pending cases and the legal issues they present, the public can more easily identify cases with statewide consequences before they are decided. People are more likely to trust and respect decisions that are made in the light of day and lead all of us, hopefully, to believe in the legitimacy of our courts. According to the ACLU, Wisconsin is only one of 6 states that posts new cases online in a timely manner, provides timely information about legal issues presented by cases, makes schedules available and free for the public, and also make attorney briefings accessible and free for the public. Everyone benefits from transparency into our court system. It's up to all of us to demand that our state's highest court continues to keep this high bar. As federal courts have grown increasingly hostile to the protection of civil liberties, such as with abortion and redistricting, state Supreme Courts play an especially important role in protecting and expanding our rights. As we do in all states, Wisconsin has its own constitution, which can and often does go further than the United States Constitution to protect our rights. Also significant is that our state high court has the final word on interpreting a state's constitution without threat of U.S. Supreme Court innovation or intervention. As with our first webinar, we have a fine panel tonight to address these issues. Professor Chad Oldfather will explain how over the years, judicial norms have eroded in our polarized time and explain how new methodologies of textualism and originalism have shifted much decision-making away from the exercise of good judgment by justices of good character. Professor Rob Yablon of the State Institute Research Institute of the UW Law School will speak on the different roles of judges on circuit courts from that of the role of a Supreme Court justice. He will discuss how we, as citizens and voters, need to filter out the partisanship and the multitude of campaign ads so we are able to assess the qualifications of each candidate's ability to future Supreme Court justice. And attorney Jeff Mandell of Law Forward will address the crucial work of the state Supreme Court in enforcing the separation of powers doctrine. Responsibility of this court to curtail the encroachment of power grabs by either the legislature or those executive branches and keep the balance of powers and the rule of law intact amongst our three branches. He will also address the cases now pending in the Supreme Court and those in the lower courts that will likely be before the Supreme Court after the new justice is sworn in. So let us begin. Our first speaker tonight is, as noted, Professor Chad Oldfather, law professor of Marquette Law School. He teaches courses in federal and state constitutional law, judging and the judicial process, and the jurisprudence of sport, and has published in each of these areas. He has published widely on topics related to courts, judging, and the judicial process. He has lectured to audiences of academics, lawyers, and judges, and was awarded the Howard B. Eisenberg Prize by the American Academy of Appellate Lawyers. And finally, I'd like to note that we are privileged to have him discuss his latest book, Judges, Judging, and Judgment, Character, Wisdom, and Humility in a Polarized World, just published by Cambridge University Press in January. Welcome, Chad.
Thanks, Joan. I'll use that as an opportunity to do a little subtle product placement here. Available everywhere fine books are sold.
Excuse me, Chad, just a minute. Delaney, I would like to get to the speaker, just the speaker on the screen. Can you do so? Hello?
Yep, keep going, Joan.
Yes, I would like Chad to be this full screen as he speaks. There we go. Thank you.
All right. So thanks again, Joan, and thanks to all of you for being here. Obviously, this is important and timely, an important and timely discussion that we're having. And it's, of course, a discussion we're having in the shadow of an upcoming election for the state Supreme Court. And I'm going to refer to that a little bit, but I'm also going to be in general, a little more abstract in what I discuss. So a bit of background, and I think this may have come up in the last session, but judicial elections, of course, have been around for a long time, but for the most part, they've been fairly sleepy affairs. I think it's fair to say that in most places, until fairly recently, if one had become a judge and nonetheless had to stand for re-election, as long as you hadn't done anything too scandalous, you were likely to be unopposed, and it was a role that you'd keep, and nobody paid too much attention, and certainly there wasn't a lot of money that was flowing into these elections the way we now see. So what happened? Well, it's a complicated story, and I'll gloss over a lot of the details. But one thing, of course, that happened is our world has become much more polarized than it was a few decades ago. And as that was happening, people with money and an interest in spending some of that money on political campaigns woke up to the fact that state Supreme Courts have quite a bit of power. And also did a little bit of math and calculated that it's a whole lot easier to affect the composition of a relatively small body, like a 7-member court, than it is to change the composition or affect the composition of a much larger one, like a legislature, right? So in essence, your dollar goes farther in a judicial campaign than it might in another context. And I think that has been a big part of what has fueled what we've seen. Obviously, the fact that Wisconsin is a purple state where change in the balance really does have consequences, not only locally, but also nationally as well. All of those things have played into this. Right, so that's been a big part. Joan mentioned I was going to talk about some of the background changes, the atmospheric changes relating to judging that have happened. That's a big one. We live in a polarized culture. The profession itself has become increasingly polarized. The path to becoming a judge, whether it's through appointment or through election, has likewise become one where affiliation with a particular team does seem to matter a lot more than it once did. There are other things that have changed over the preceding decades also. One of them is the simple math of courts' caseloads. For court systems as a whole, and therefore for most of the judges in them, caseloads have risen dramatically. The pretty much universally agreed on start date for this is 1960. And that increase has flattened over the last 10 years or so. But up until that point, it was very much the case that the trajectory was upward, and today's judges, no doubt, individually have many, many more, multiples more cases on their dockets than did their predecessors of 50, 60, 70 years ago. And that had to be dealt with. Not surprisingly, right, the need to deal with these cases in a somewhat expeditious manner required that there be changes to the processes by which they are handled. So that has, again, been the story for most judges. There's a little bit of a counter story when it comes to courts like the state Supreme Court, or really any Supreme Court, because the device that that was used there to deal with this increasingly large caseload was to essentially give them control over their dockets, right? So you don't get to have your case taken to the U.S. Supreme Court or the Wisconsin Supreme Court automatically. You have to ask them to take it, which basically entails demonstrating to them that there's some reason why it's important that they get involved. The question is significant, and so forth, right? So it's changed the nature of their work too. Although in a way that that leads to their cases really not being representative of the full range of cases before the entire court system in lots of significant ways, right? So again, the key point here is that it's led to these fundamental shifts in the nature of the relationship between judges and their work. And again, there's lots of complexity and nuance to that. I want to focus right now on one piece of it, but one last bit of background, which is I think it's fair to say that a lot of the features of the judicial system have been designed, at least in part, to account for human psychology, right? To account for the fact that that we're all susceptible to bias. From a variety of sources and in a variety of ways, but the one we're most concerned about when it comes to courts in general, and I think especially lately, is politics, right? I think it's fairly easy to appreciate when one pauses to ponder it, that the arguments in favor of, say, a president or a governor having a lot of power have a certain appeal when you happen to like that president or governor and they're doing things that you happen to like, right? And you're like, oh yeah, that makes sense. We should allow them to do those things. The converse is very much true when you don't happen to like the president or the governor and they're using the power they have to do things that you don't like. And that sort of influence, right? It's often referred to as motivated reasoning. Is something that we're all susceptible to, and judges are no exceptions to that, right? We tend to interpret facts, we tend to interpret legal standards in ways that will lead us to a result that we prefer in a given sort of situation. And so, like I said, I think even though this hasn't necessarily always been expressly the design, and it's not certainly the sole reason for why the legal system functions as it does, but a lot of what the legal system has traditionally required in terms of process can be thought about as as mechanisms to channel judges away from that, to get them to consider questions from all sides, to think about the long view, to think not just about this case, but also about the next case and the one after that, and what happens when, you know, the president or the governor isn't somebody who I happen to like. One of the big features of the system that I think does that, or has historically done that, is judicial opinions, right? By which I just mean the statements of reasons that courts customarily give to explain the reasoning behind the decisions that they've made. And there are lots of reasons why opinions exist, right? They allow us as lawyers, us as members of the public, to figure out what the law is so that we can live our lives according to the law and so forth. But they also serve as a discipline on thought. Makes intuitive sense, I think, that if we have to provide a detailed explanation of our thinking and provide a roadmap of the reasoning that we use to get to a particular conclusion, the process of generating that, the process of writing it out, leads us to be more careful. We're going to expose gaps in our thinking. We will pause to recognize things we hadn't thought about before, and our decision-making is going to be better, generally speaking, as a result of that. Well, one of the things that's happened over time is that because of this increasing amount of cases that judges have to deal with, they've ended up delegating a lot of that work. A lot of that work gets delegated to people called law clerks, right, which are usually lawyers fresh out of law school, which means a few things. It means they're young. It means they're inexperienced. It also means they're pretty talented, and they're eager to please, right? This is kind of their first real lawyer job. They've got a boss who they want to please. And when that boss says, well,
Stop
you know,
navigation.
Here's where I'm thinking about going with this particular case, the law clerk will be like, yes, I'm going to write the best explanation, the best justification for that decision that I can come up with, right? So what that means is that judges are not engaging with that work in the same way that they historically did. They're not writing, they're editing. And what they're editing is less probably something that was designed to, you know, really explore things from all sides, and more something that's produced by this eager and talented young lawyer who's really going to want to tell a story that impresses their judge and is consistent with the instruction that the judge has given to them, right? So it's going to be a confirmation more so than a test of the judge's initial inclinations, right? And this is just one example. I go through several in the book of ways in which the various mechanisms within the system and forces external to the system have shifted both to weaken the force of these disciplining measures and increase the potential lure of ideology. And as all this has been going on, there's meanwhile been accumulating this mounting evidence. There's lots of it now, produced by both political scientists and by legal scholars, to the effect that, yes, things like ideology definitely do affect judicial decision-making, which is not terribly surprising when you think about it, that at least across the run of cases, and in the particularly controversial ones, so-called conservative judges are going to come out one way and liberal judges the other way, and so forth, right? And there's lots more I could say about that, but I'll just kind of gloss over it for now. All right, so the question then becomes, what do we do about this? Right? It's kind of a recognized concern. So what do we do about it? Well, one prominent response, and it's a response mostly associated with the political right, is to say, well, you know, what we have to do is constrain judges even more. And the way to do that is to impose on them a methodology, right? Or a recipe for decision-making, a formula that they can follow that will keep them from being led astray and lead them to the right conclusion. And there are sort of two primary varieties of methodologies that most often get discussed. One of them, called textualism, relates to the interpretation of statutes, right? So the laws passed by the legislature, and very roughly speaking, what textualism says is, if I got to figure out what a statute means, my job is to focus primarily, exclusively, if I can, on the set of words that the legislature passed, right? And so I'm going to be looking at dictionaries and really kind of doing this linguistic exercise rather than trying to discern what it was that the legislature was intending in some more abstract sense to do. And that's a very simplified explanation of what textualism is, but the goal is, right, to make it more about words and less about purpose. Originalism is the version that comes into play when we're talking about interpreting constitutions, right? And there, the idea is, I think the argument for it sounds something like this: a constitution is law, like any other law. It's got a meaning when it's enacted or adopted. That meaning doesn't change unless and until the Constitution has been amended. Therefore, the job of the judge, of the law interpreter, is to figure out what it meant at the time it was enacted. And there are lots of bases on which to critique that, but the recipe that gets delivered is your job, judges, is to figure out how it was originally understood, right? Which means you're going to have to do a lot of history. You're going to have to go digging around in historical sources and try to make sense of it. And you're going to have to do it on this fairly constrained timeline in which you have to decide a case. So those are the methodological solutions that get proposed. And one thing about them, undeniably true, I think, is that they work extraordinarily well in a marketing sense. Right? They're really easy to pitch. They have an intuitive appeal as something that seems mechanical or algorithmic that allows someone who espouses them to say, well, I'm just following the law. Right? I'm doing what I'm supposed to do. I follow the law. And that's typically contrasted with, and my opponent, my colleague who chooses not to use these methodologies, they're just making things up. Right? I'm doing law. They're doing whatever they want. That's how it's portrayed. When you actually look under the hood, you find, though, that these methodologies don't actually remove the need for judges to exercise judgment, right? Again, the product placement, it's not an accident that we've got judges, judging, and judgment. The point being to emphasize that it's the same root that's in all three of those words, right? Judging by judges necessarily entails the exercise of judgment. And if you read any commentary by thoughtful advocates of originalism and textualism, they acknowledge that, right? So I think that what ends up happening is it's not that they remove the need for judgment from the system. They just move it to a different place and conceal it a bit. And what that, I think, ends up meaning is that the constraint that they purport to provide ends up being a bit of an illusion, right? That the potential for the influences that I was discussing earlier is still there. Ideology can still work its magic, or black magic, as the case may be, on judges' decision-making. This just gives a sort of mask, oftentimes. None of which is to say that what they call for is bad, right? That it's bad to look into the original understanding of what a constitutional provision was designed to do, that it's bad to look at the text. Those are both good things. I just don't think they should be the exclusive thing. All right, so what do we do about it? Well, what I don't have for you is an answer that's gonna, give you a ticket that you can cash out, in the next month or so, in the context of this upcoming election, because the project that I'm working on here is definitely more of a medium and really realistically longer term project, if in fact it's not just castles in the sky sort of project. I don't think so. There are others in this movement as well. But essentially, right, if judges are necessarily exercising judgment, then it seems the conclusion is we should try to find judges who have good judgment. And that's good marketing too, I suppose, and maybe open to some of the same critiques. Right, in the sense of saying, well, you're just sitting here, Oldfather, telling us that what you want is judges who decide things the way you think they should be decided, and that's who you think has a good judgment. And I think other people have good judgment, even though they'll decide things differently. And I don't think it's as simple as that, right? I think good judgment is really hard to capture in any sort of precise or pithy way. But the fact that something's difficult to define doesn't mean that it doesn't exist. I do attempt to get a little more precise about it in the book. And as I've said, there are other people doing similar sort of work. For now, I'll just say, I'm sure every one of us can think of people in our lives who we regard as having good judgment and who other people also regard as having good judgment. And that the reverse is true as well. That we know people who have not so good judgment. And, oftentimes, unfortunately, those people are more than happy to share their advice. But set that aside, right? We know people who can take a detached view, who are better able to resist the pull of motivated reasoning, who we might take a difficult problem to, who we might go to for advice, even if we know that we disagree with them politically or otherwise. Because that's really how it's supposed to work, right? One of the things about the rule of law, it seems to me, and I don't think this is hardly controversial, is sometimes your team loses, right? That's just how it is. Sometimes you're going to win them, sometimes you're going to lose them. And the people I want deciding are the people who I understand and others understand, we collectively understand, are the people who are going to be fair and take that detached perspective and really think about things and resist the pull of ideology and motivated reasoning. Again, not much of a short-term lesson there. I think really the place for this discussion to really start is within the profession, within the law schools, and we have to sort of rebuild, I think, some of what we've lost as polarization has entered the profession. And with that, I'll stop. I've maybe even talked a little bit too long, but I do look forward to hearing what Rob and Jeff have to say and to your questions as well. So thank you again.
Yeah, Chad, I have a question for you. Can you explain what intellectual humility is that you talk about in your book?
Sure. Yeah. I mean, and that's one of the key characteristics that I advocate in favor of, right, is judges who have intellectual humility. And, essentially, I mean, I guess I describe it at some point as being the sort of measure twice, cut once approach to thinking, right? That just sort of being mindful of the limits of our own knowledge. And being mindful of the fact that we are all susceptible to all of these various psychological pulls, all of these biases, being mindful of the fact that, one characteristic of psychological biases is they're super easy to see at work in everyone else, right? It's easy to see that other people's thinking is biased, and yet we don't ever imagine that of ourselves, right? And that's the thing about blind spots, is you can't see them. Yet I think it's good to be mindful of the fact that we all have them. We don't know what they are, because otherwise we wouldn't have them, but we've got them. So it's really meant to be this sort of like, am I sure? Am I sure that I know what I think I know? Let me double check before I move forward. So it's a kind of caution. It's not timidity necessarily, right? I don't think it precludes judges from doing things that are bold and from taking strong positions, but be an extra sure before you do it.
And it sounds like it's a good guardrail against arrogant position.
I would agree with that. Yes.
Well, thank you. Thank you very much, Chad.
Thank you.
Hey, our second speaker tonight is Professor and Attorney Rob Yablon of the State Democracy Research Initiative at the UW Law School. He's a professor at the Law at the Law School, where he teaches the law of democracy, civil procedure, and federal jurisdiction. He also serves as the faculty co-director of State Democracy Research Initiative, which seeks to advance research and dialogue on state-level democracy, government institutions, and public law across the nation. He graduated from the University of Wisconsin and Yale Law School, where he was the articles editor of the Yale Law Journal. He served as a law clerk for the U.S. Supreme Court Justices Ruth Bader Ginsburg and Sonia Sotomayor. Thank you, Rob. Please, welcome to have you.
Well, thank you to the League for hosting this event, and Jane and Joan, thank you so much for organizing and also for providing some of those introductory remarks, which actually make my job a little bit easier. And I will try to be fairly brief because I want to make sure that we have enough time for some questions and discussion. What I think I will try to do is begin with just some basics about the Wisconsin Supreme Court, including its role in our system of government, and a little bit about how and why we elect our justices. Then I'll briefly give just a few thoughts and maybe build on what Chad's already said about the characteristics and qualities that we might want in our judges and justices. And then I'll say a bit about judicial campaigns, including the role of money in those campaigns. So to start with some basics, right, our state constitution gives the Wisconsin Supreme Court, quote, superintending and administrative authority over all courts, as well as, quote, appellate jurisdiction over all courts. That's another way of saying that the state Supreme Court sits at the apex of our state's judicial branch, above our trial level courts, including our circuit courts, above our intermediate courts of appeals. The state's trial level courts hear hundreds of thousands of cases. And those trial level courts are the central trial level courts are our county level circuit courts. And that's where both of the candidates for the state Supreme Court this year sit right now. Those are high volume courts. Joan said I would say just a little bit about the different roles of circuit and Supreme Court justices. Circuit courts are in some ways, the real engines of our judicial branch, processing a lot of cases that come through, both civil and criminal cases. They are the courts that hold trials and hearings and do a lot of fact finding. The judges on those courts often issue rulings without written opinions, or at least without significant written opinions. And frankly, it would be unrealistic for them to write opinions in all of the many, many cases that are on their dockets and that they're forced to process and decide. So hundreds of thousands of cases go through our state's trial level courts. A fraction of those cases get appealed up to our intermediate appellate courts. And then a fraction of those cases are ones in which a party will ask the state Supreme Court to get involved. And as Chad mentioned, our state Supreme Court is a court of discretionary review. It has significant control over its docket. So of the many hundreds of petitions that it receives every year, it will pick only a few dozen of those cases that it will actually decide. And so its role is really to set legal precedent. It's providing final resolution of major controversies about the meaning of state laws and our state constitution. It sometimes will hear federal claims as well, particularly in criminal cases, right? And the cases that it's most likely to choose to take are ones where there's been a real disagreement or confusion about the state of the law, right? Cases in which there really is a clear statewide significance, right? And it is in these cases, the law, not the facts, that the state Supreme Court is particularly resolving. Clearly, cases involve facts, and sometimes there will be debates about facts that the Wisconsin Supreme Court will consider. But the reason for its intervention is because there is a question of law that needs resolving. Right? And often those are highly contentious and controversial cases. Now, our state Supreme Court consists of 7 justices. Those justices serve 10-year terms. And the fact that we elect our justices, as well as our lower court judges, distinguishes Wisconsin from the federal courts. Wisconsin is similar to most other states in having some form of judicial election. The majority of states elect their judges in one form or another, including sometimes through retention elections. So why is it that we in Wisconsin and in many other states elect our judges as opposed to following the appointment model that we have at the federal level? I will say, just to give you just a quick dose of history, that choice to elect our judges was one of the most contentious and highly debated topics at the Wisconsin Constitutional Conventions of the 1840s. Uniformly, our Constitution's drafters were committed to having a judiciary that was independent from the other branches and that could be counted on to check those other branches when necessary. And their commitment to judicial independence built on the ideas of the federal Constitution's framers. Right? Alexander Hamilton, for example, famously described the need for independent judges to act with, quote, fortitude, to do their duty as faithful guardians of the Constitution. And he wrote that, quote, the independence of judges may be an essential safeguard against the effects of occasional ill humors in society, including, quote, the arts of designing men who seek to occasion dangerous innovations in government and serious oppressions. Right? So for the federal framers, judicial independence was a priority, and for them, that meant having an appointed judiciary with life tenured judges. Wisconsin's framers made a different choice, and it was a choice that was being made in a number of other states around the country, both at that time and after. Based on experience at the federal level in states and territories, their prevailing view was that appointment had too often proved to be a recipe for, quote, partisan influence and corruption. They felt that it was better ultimately to put judicial selection in the hands of the people, rather than in the hands of one of the other branches that the court itself might be asked to check. One of the statements that you get from the Wisconsin Constitutional Convention, for example, came from the committee tasked with drafting the judiciary article, and it wrote, quote, the judicial power, a distinct co-equal department, should be wholly independent of the others, instead emanating from the people, the true source of all political power. Right? So election, they concluded, would be preferable and more in keeping with our foundational democratic principles. Right? Now, there was concern that elections would maybe be no less prone to partisanship than appointment would be. The way that the framers attempted to deal with that was by creating a system of nonpartisan elections in Wisconsin. So from the beginning in our state, judicial elections have been set apart from the elections for our partisan state offices, for governor, for attorney general, for the state legislature. And what the creators of those provisions had in mind was that this would help insulate those elections from what they called, quote, the heat of partisan feeling or the efforts of demagogues. So, that may or may not hold up today, and I'll say a little bit more about that when I talk about judicial campaigning, but that was the ideal, that the people would have a say, that was consistent with notions of popular sovereignty. It would make the judiciary more independent. And if we had our judicial elections occur at a time separate from our elections for partisan offices, that the people would be maybe more reflective and make better choices. Now, having said a little bit about what the Wisconsin Supreme Court does, its structure, the nature of judicial elections, that takes me to the second thing that I wanted to talk about, and I'll do this just briefly, offer just a few thoughts on the characteristics and qualities that we might want in justices. And this is building in many ways on what Chad has already said, right? He talked about the desire to have judges and justices who are capable of resisting motivated reasoning. He talked about the value of intellectual humility and so on. But let me just offer a few additional thoughts on characteristics and qualities. One, and this one is fairly obvious, we would want our judges and justices to have legal knowledge and experience. And the state constitution basically articulates that as a minimum. It requires that justices be licensed attorneys who have practiced law for at least 5 years immediately prior to their appointment. So they want, the framers of the Wisconsin Constitution wanted to assure that there was experience. Now, what that experience could be might vary. And on our current Supreme Court, we have a range of professional experiences that our justices have had. A number of them have been involved in criminal law as prosecutors, both at the state and federal level. Several of them have worked in private practice. Several of them have had various roles in the state executive branch. And those kind of experiences are in line with the experiences that the candidates in the race this year also bring to the table. Right. All of the judges, justices on our state Supreme Court now previously served on lower courts. 6 of them on circuit courts, which again is the experience that both of the candidates currently for the state Supreme Court bring to the table. So, you want those judges to have experience, and with that experience, you hope will come some technical competence and some legal acumen. Because as I indicated before, sitting at the apex of our judicial system, the state Supreme Court is often choosing the most difficult and contentious cases to take. And these cases sometimes can be complicated, and you want justices who really are capable of understanding all of the nuances of the disputes that they are hearing and rendering decisions that maybe are not overly broad, that have a necessary subtlety, that are thinking in an anticipatory way about what the next case or what the implications of a decision might be. Another characteristic that I will mention, which again is closely associated with, with an important characteristic of our judiciary, and that's independence. Right? If we want an independent judiciary, we ought to want independent-minded judges. Right? Someone who is willing to say no, including to friends and allies, right? Someone who is not going to be a rubber stamp for political actors or partisan interests. Someone who takes seriously their institutional role of being a check on other branches, whoever may be in control of those branches. Now, there are other characteristics that I think are important given the multi-member nature of the Wisconsin Supreme Court. You have 7 people who are trying to work together to resolve cases. And sometimes they may agree, sometimes they may disagree with each other, but they need to work with one another. And so, some characteristics, humility was already mentioned, open-mindedness, collegiality. These are characteristics that we ought to think about as we're electing our judges. And then a final one, right, is integrity and ethics. Right? The court needs to have the public's confidence in order to do its work. And the public is more likely to be confident if there are not ethical questions surrounding the justices that are hearing the cases, if they feel like the judges that are hearing the cases are really people of integrity. I could go on about judicial characteristics. Again, Chad, I will give you a little product placement. Chad has a whole book that addresses some of that. But I think that gives you, a sense of some of the things that we ought to be thinking about as we're choosing our justices. Now, the final thing that I wanted to talk about are judicial campaigns, including the role of money in those campaigns. And what I'll say here is that what judges are asked to do as candidates is quite different from what they're asked to do on the bench. Right? Those are very different roles. And frankly, there may not be a particularly strong correlation between one's skills as a campaigner and one's potential to excel as a judge or justice. And in fact, in today's world, what may be required to run a competitive and successful campaign sometimes may feel like it's in some tension with our ideals of an independent and impartial judge. So on the campaign trail, what are judges supposed to be doing? Well, the message that we've gotten, including from the U.S. Supreme Court in recent decades, is that judges are allowed to do most, but not all, of what other political candidates do. They are allowed to express their opinions about current events. They're allowed to talk about their values, right? And in some ways, this is natural, given that we are having campaigns and the people want to learn something about the folks who they're voting for. So this idea that judges are fairly free, have a First Amendment right to express themselves on the campaign trail, came out of a U.S. Supreme Court case decided 20 plus years ago called Republican Party of Minnesota versus White. That case involved a Minnesota judicial ethics rule that prohibited judicial candidates from announcing their views on, quote, disputed legal or political issues. And the challengers to that rule wanted to actually say more about their views on legal and political issues. One of the challengers included a candidate for judicial office who wanted to speak out because he didn't think very highly of some of the decisions that the Minnesota Supreme Court had issued on issues like crime and welfare and abortion. And the state responded, well, allowing you to speak out, we're concerned, would undermine judicial impartiality and integrity. The U.S. Supreme Court rejected that justification. Justice Scalia wrote that what due process requires is for judges to avoid bias for or against either party to a proceeding. But it doesn't require them to avoid the expression of views on issues. He said, quote, a judge's lack of predisposition regarding relevant legal issues in a case has never been thought a necessary component of equal justice, and with good reason. For one thing, it is virtually impossible to find a judge who does not have preconceptions about the law, right? Justice Scalia thought that a lack of preconception was more likely to be evidence of, quote, a lack of qualification than evidence of a lack of bias, right? So after that decision in Republican Party of Minnesota versus White, the door really was opened more than it had been before for judges to speak out on the campaign trail. And that was an important part of the shift that Chad alluded to in the way that we run judicial campaigns today, and to some extent in the more partisan nature of those campaigns. Now, what judges have to avoid, and this is where they are still a bit different from candidates for other political offices. Candidates for political offices, they'll often make promises to voters. I will do this. I will vote for this bill or that bill. Judicial candidates in Wisconsin, and this is true in similar ways in many states, they are prohibited from making, quote, pledges, promises, or commitments to rule in particular ways, in particular cases. Right? So they can express their views in a fairly general way. They can describe what they think the law may or may not require generally, but they are not supposed to reduce that to, and on this case, I would therefore vote a particular way. Okay. Well, what about money? And this is the last thing that I'll talk about, right? So if on the campaign trail, judges are allowed and maybe even expected to say more about their positions, then potential funders also may have more of a sense of what a judge or justice might be like on the bench. And what arguments they may or may not embrace. And so that's given funders maybe more of a reason to get involved in judicial races, especially in this age when a lot of high stakes issues have been pushed to state Supreme Courts in particular. Often because the U.S. Supreme Court has suggested, you know what, this is not an issue for us, it's an issue for someone else, right? It did that in the abortion context. It did it in the partisan gerrymandering context. And so what we've seen in Wisconsin and in other places is a continual increase in the amount of money that's being spent on these races, including in Wisconsin in 2023, where we had the most expensive judicial election in history with more than $50 million spent. About 2/3 of that money was outside spending, meaning expenditures that are made by organizations other than the candidates' campaign committees. And one consequence of that is when a lot of outside money is in a race, then candidates often lose control to some extent of their own messaging. Right? If these are really independent expenditures, they're not even the ones who are choosing what ads are being run on their behalf or against their opponents. Right? Now, this year, we're seeing more of the same. We've already seen outside spending in the races. We've seen political parties endorsing and spending money in this race as they have in other recent races. So even though these races remain formally nonpartisan, in our modern world of campaigning, it does seem like viable candidates really do need to try to get the backing of one or the other major political parties. So we've seen deep-pocketed backers on both sides of this. We've seen both political parties get involved, and we've seen many millions of dollars in ad buys already made. I saw an estimate from the Brennan Center just this week that there have been $15+ million already spent or reserved on television ads thus far, and that's only going to increase. Now, here's what I think is going to be interesting to watch in the next 5 weeks or so, and that is there seems to be one particular outside spender who may get a whole lot of attention, and that's Elon Musk, who has indicated that he is going to get involved in this race, has already spent some money. So not only does he have a high profile because he is the single richest person in the world, but he also has a high profile because of the role that he's currently playing in the federal government. And so what will his involvement entail? Well, for one thing, I think that it is going to increase the likelihood that this race will set a new record for the amount of money that we'll spend, because not only are we going to have money from him, but there's going to be a counter mobilization effort, right? His opponents are going to want to exact a price for his involvement by convincing people that now this is all the more reason why they should invest in the race to stop him and reduce the impact of his money. Second, I think that this means that the race is going to be even more nationalized than it would have otherwise been, and even more nationalized than our already fairly nationalized races have been. Right? It may mean that this race in part becomes a referendum on people's views of Elon Musk, of the early days of the Trump administration, even though for Wisconsinites, there's clearly a lot more at stake than just people's feelings about national politics. Right. Finally, and I think this is something that I'm interested to see whether we get more on it in the coming weeks, right? Musk not only is the most deep-pocketed of individuals, not only is so intimately involved right now in a presidential administration doing things that are, highly controversial, but he also is someone who has been quite outspoken about judges. He, in just the last few weeks, has expressed support for impeaching federal judges who have issued rulings against the Trump administration. He has referred to the need for, quote, an immediate wave of judicial impeachments. He branded one judge that ruled against the administration as corrupt and another as evil. And, these echo attacks that we've seen from President Trump and others in his orbit on judges for quite a long time. Right? These attacks in recent weeks led the American Bar Association to issue a strong condemnation, expressing concern that this was designed to intimidate judges and that it was at odds with the idea that we have a system of separated powers among co-equal branches. So the question, I think, will be, what will voters make of the fact that one of the candidates in this race seems to be backed by someone who has expressed a lot of disdain for the whole notion of an independent judiciary, right? And what will that candidate have to say about receiving support from such an individual, right? And so I'm curious myself to see how this plays out in the coming weeks. One final thing that I'll say, I'm going on too long, but the final thing that I'll say is as we are deluged by campaign ads in these next few weeks, you will see that a disproportionate number of these ads are trying to either boost one candidate as tough on crime or denigrate another as being soft on crime, right? And these messages are out there because they seem to strike a chord with the public, but they give a mistaken impression about really what the state Supreme Court is doing and what's principally at stake in this race. Right? Members of the Wisconsin Supreme Court are not directly involved in criminal sentencing, right? That is for lower court judges. Of course, they do decide some criminal cases, but those tend not to be the court's biggest ticket cases, right? And I think what's notable, if you look at the groups that are funding these expenditures on these soft on crime, tough on crime ads, for the most part, they are groups and individuals that do not have a primary interest in criminal justice issues. They have other agendas and reasons why they're favoring one candidate over another. And they're using these ads as a bit of a stalking horse to try to get the public to vote for the candidate that they would like for other reasons. right? And so I would urge you all to be educated consumers of these ads and to spread the word from others to others to help them understand, what really is at stake in these races. And my hope is that over time, these kind of soft on crime, tough on crime ads become less prominent because people have wised up and realized that that's not what these races are predominantly about. Okay, so let me stop there. Apologies if I did go on too long, but would love to hear from Jeff as well.
Thank you. Thank you very much. Really appreciate it, Rob. Do you just have any advice as to where a voter can find out about the political alliances of judicial candidates donors? Is there a site that we can go to?
So one that I'll mention, and Jeff or Chad, feel free to jump in as well. I know that Wisconsin Democracy Campaign tracks the money in the race, and so they have a website. I know that the Brennan Center for Justice is tracking the ad spending, and actually on their website you can find, I don't know if this is totally comprehensive, but what seems to be a fairly comprehensive listing of all of the ads that are being run and who is supporting them and how much money is being spent on those ads. Maybe there are other resources out there as well.
Okay, thank you very much. Okay, our final speaker is attorney Jeff Mandell. Jeff is the general counsel of Law Forward, a nonpartisan, nonprofit, pro-democracy law firm founded in 2020 with a mission of protecting democracy and working to ensure free elections. Jeff is widely recognized as one of Wisconsin's leading experts in election law and constitutional litigation. He has handled various high-profile cases before the Wisconsin Supreme Court involving redistricting, absentee ballot drop boxes, and separation of powers issues. He's a graduate of the University of Chicago Law School. He also served as a law clerk to the Honorable A. Raymond Roundoff at the U.S. Court of Appeals for the D.C. Circuit. Welcome.
Thanks, Joan.
Thank you.
It's a pleasure to be here. It's always a pleasure to be speaking with the League. The League and Law Forward have a long-standing relationship, and we are honored to represent the League of Women Voters in a number of cases, including a couple I'm going to talk about briefly. Let me just tag one thing onto what Rob said, and then I'm going to talk a little bit about what's coming down the pike in the courts. But, Rob talked about Elon Musk's particular interest in courts and in judges. I just want to note, and I don't think there's been much attention to this, but Tesla, which Elon Musk, is the founder and primary owner of, just filed a lawsuit challenging Wisconsin law about how you sell cars in this state, and therefore has a significant stake in the next year or two about how Wisconsin courts operate and what that ruling is going to look like. Because Tesla is trying to undo sort of the basic foundations of how car dealerships and car sales in the state of Wisconsin work. But let me talk more broadly about the kinds of cases that I think we're going to see at the Wisconsin Supreme Court and try to put in slightly more concrete terms some of the stakes of the election that we're in the midst of. Because I agree with Rob that there is a significant disconnect between what we see in the campaign commercials and some of the public discourse about the race and what the court and justices actually do. I want to focus this evening briefly on the kinds of cases that really relate to democracy and civil rights and the separation of powers that we're going to see at the court, that we anticipate seeing next year, and then that could be coming shortly thereafter. And thank you, Martha, in the chat. You're correct. Elon Musk didn't found Tesla. He took over Tesla and made it much larger and into the company it is today, but it's not his company initially. Rob noted earlier that one of the things about, and he was building on something Chad said, that one of the things that is unique about the Wisconsin Supreme Court in our court system here in Wisconsin that we have to keep in mind is that it gets to choose its own docket, that the Wisconsin Supreme Court gets to decide what cases it hears, like most Supreme Courts, including the US Supreme Court. And Rob said correctly that most terms the court hears only a few dozen cases, sometimes even less. And I would suggest to you that makes it all the more remarkable how many of these cases are about democracy and fundamental issues. Because there are, of course, business disputes, family law cases, criminal appeals, and other issues that work their way up to the Wisconsin Supreme Court. The court is, as Rob explained, fundamentally designed to help provide clarity to the lower courts and to make sure that the law is the same around the state and to resolve open questions in the law. And yet, so many of those open questions these days are major issues contested in our political sphere. So here's just a quick rundown of things that we reasonably expect that we know are working their way through the justice system and seem unlikely to be resolved before the end of the court's term this summer. So many of these will be reasonably expected to be at the Wisconsin Supreme Court next year, or maybe a couple of them will linger for a year after that. There are several cases seeking to limit people's rights to vote by absentee ballot in various ways. And the League of Women Voters is involved in a number of those cases, and in fact is the lead plaintiff in one of those cases. There are at least 2 votes about voting rights for individuals with disabilities. There is a case about whether every voter needs to produce documentary proof of their American citizenship. There's a case about whether the city of Milwaukee is obligated to purge 150,000 registered voters off of its voter rolls. There is a case, this is a separation of powers one, and I'll come back and talk a little more about the separation of powers in a couple minutes, but there's a case about whether the legislature violates the state constitution when it insists that private lawyers it hires on its own behalf, rather than the Wisconsin Department of Justice, gets to speak for the state of Wisconsin in court cases. There's a case about whether the Wisconsin Elections Commission is able and authorized to delegate some of its work to the state's chief elections officer. There is a case about whether small municipalities in Wisconsin can choose to stop using electronic voting machines and return to counting ballots by hand, even though the electronic voting machines were purchased using taxpayer dollars, and even though it is widely known and demonstrated in multiple studies that hand counting ballots is less precise and accurate. There are several cases of criminal prosecution against the lawyers who created and executed the fraudulent elector scheme in 2020 and tried to overturn the will of the voters, and whether those actions violate Wisconsin criminal law. There's a dispute about whether former Wisconsin Supreme Court Justice Michael Gableman will face any ethical consequences for his violations of ethics rules as he led the Wisconsin Assembly's sham investigation of the 2020 election and deliberately spread false conspiracy theories. There's a dispute about who has the legal right to bring a lawsuit against pollution or other widespread hazards that affect most people in the state in similar manners. There's a case about whether the Wisconsin Constitution protects the right to abortion. And there are questions about whether Scott Walker's trademark anti-union law, 2011 Wisconsin Act 10, violates the Wisconsin Constitution by favoring those unions that endorsed his gubernatorial campaign and punishing those unions that did not endorse his campaign. Now, a couple of these things touch on the separation of powers, and Joan specifically asked me, because this is a sophisticated audience that understands how the gerrymander has distorted democracy in the state of Wisconsin over the last decade plus, asked me to talk specifically about separation of powers cases. And there have been several just in the last term or so that we continue to see cases about the governor's partial veto authority and where the line is between gubernatorial vetoes and legislative power. We have seen 2 cases that the governor brought against the legislature about whether and in what circumstances the legislature can essentially stop the administration from executing and faithfully carrying out the law because maybe a few members of the legislature or a legislative committee oppose the action the governor wants to take, and can the legislature stop it through that committee, or does it require a vote of the entire legislature? We saw a case about the Knowles-Nelson Stewardship Program on this exact issue last term. That case was decided, and not on a strictly ideological basis, that case was decided on a 6-to-1 vote in favor of the governor. And there's another case this term about whether a committee of the legislature can permanently suspend or block regulations, or whether that requires a vote of the entire legislature. There's a dispute between the attorney general and the legislature. I already mentioned one about whether the legislature can show up in court and claim to speak for the state, even if it's saying opposite things of the attorney general claiming to speak for the state. There's also one about who controls what happens with settlement funds. When the attorney general brings a case on behalf of the state of Wisconsin and either wins a case or settles a case and monetary damages are paid to the taxpayers, to the state, who controls how that money is spent or what exactly we do with it? And I expect we'll see more of these kinds of separation of powers cases, and they come up fairly quickly. The court, one of the roles of the Supreme Court is to act as, and our courts in general, is to act as a referee when our political branches, the legislature and the governor, can't agree on things, right? We see this in redistricting cases, we see it in other contexts, and often these cases come up as original actions that go straight to the Supreme Court, and so they can move fairly quickly. And I expect we're going to see more of them because for 12 years, we had a legislature, because of the nation's most extreme and durable partisan gerrymander, we had a legislature that really understood it could not be challenged and it had complete power. And especially once the voters chose to put a governor of the other political party into office, we saw that legislature taking for itself more and more power, taking that power away from the executive branch, taking that power at times away from the judicial branch, taking that power away from counties and local governments. And our system of checks and balances is, I would suggest, off balance right now, out of, sort of askew. And so we're seeing the governor's office push back on this. We're seeing the attorney general's office push back on this. And we're seeing others push back on this. And I expect that we'll have a number of cases about this in the next couple of years. All of this really helps illustrate what the stakes of this are. And I think all of this, and with this I'll stop, I think all of this underscores some of the oddness that Rob was speaking about, or the mismatch between the greater nationalization of this election and the greater outpouring of funds from around the country into this judicial race in Wisconsin. The mismatch between that on the one hand and the reality that most of the hot button cases that will be decided in the Wisconsin Supreme Court really are about questions of Wisconsin law and Wisconsin government. And there's a weird disjoinder there. So with that, I'm happy to stop and take any questions or be part of the discussion. Thank you so much.
Thank you, Jeff. I have a question I know a lot of people are concerned about. Is the abortion case, do you believe will be decided before the April 1st election, or will that be after we have a new justice?
Well, to be clear, let me say 2 things. There are 2 abortion cases, And let me also note that one of the things that's slightly odd about our judicial elections in this state is we have a fairly long period between the election and the justice taking the bench. So our judicial election will be April 1st, and the new justice won't take the bench until August 1st. So the first abortion case that was argued earlier this year, argued in the fall, in fact, is about the 1849 statute and whether that statute addresses abortion or instead is an infanticide statute or touches on something else. That case, I fully expect, will be decided by the current court this term, although I would be surprised if we see the ruling before April 1st. I do think we'll see it issued by these 7 justices before the end of June. The second case, which is about whether the Wisconsin Constitution protects the right to abortion, the court accepted that case several months ago, but there has not even been a schedule for briefing or any other progress in that case as of now. And now that we're reaching the end of February, with every day that passes, it seems less and less likely that the court this term, before the new justice elected on April 1st joins the court, will hear and decide that case. So it is seeming increasingly likely that case will be pushed off till next term if it is going to be heard and decided. But it's a little bit hard to tell, and it is still possible that the court could have an expedited briefing schedule and hear argument in May and decide the case before the end of June.
And one other question, could you explain what an original action is? You referred to the fact that that's why the cases move so quickly.
Thanks for catching that. That's a really important question. As Chad and Rob both mentioned, the Wisconsin Supreme Court sits at the apex of the Wisconsin court system. And what that means is that for the most part, it is hearing cases on appellate jurisdiction, cases that have been decided by a lower court, sometimes 2 lower courts, sometimes an agency before that, and have worked their way up the court system. The Wisconsin Supreme Court is the top rung of our court system and has the final word on what state law and our state constitution mean. But there are certain circumstances in which you can go to the Wisconsin Constitution in the first instance and ask the court to exercise its original jurisdiction, to hear a case not in its appellate jurisdiction, but to be the first court, and probably the last, to hear that case. And this is something that has always been true. It's been in the Constitution as long as we've been a state. But this process has been used much more extensively in the last several years, especially since Governor Evers took office and during the COVID pandemic. We've seen a lot of use of the original action mechanism, and we see more and more cases being heard this way. And there is a certain logic to that. There's a certain benefit to, especially in high-profile disputes where you have disagreements between 2 branches of government, getting a quick resolution. But on the other hand, what you're lacking and what you're losing out on are 2 things. One is the fact finding, right? Rob talked about how the Supreme Court's primary job is not to find facts, but to decide questions of law. So where a dispute has big questions of fact, it can be harder to do that through an original action. And the other thing you're losing out on is some of the intellectual humility potentially that Chad spoke about, because one of the benefits of a case working its way through the ladder of the judicial system is you're getting the thoughts and the conclusions of different judges at different points. And hopefully that helps refine the questions, helps make them clearer, and also helps the justices think as sharply as possible about the issues before them. And if you take the case in the first instance as an original action, you don't get the benefit of those lower court thoughts.
Okay, thank you. Thank you so much, Jeff. Okay, now Kathy Ammon, member of the Impartial Justice Committee, who's been monitoring the chat, will now address your questions. Kathy, want to please take over?
First question is addressed to Professor Oldfather from Dorothy. How might law school curriculum be changed to enhance law students' development of good judgment?
Rookie mistake. I didn't unmute myself. I said some really good stuff there for a second, though. It's a good question. And I think, you know, it's the sort of thing where I think some of what law schools are doing is, or at least what some law schools are doing, is partially responsive to what I'm looking for, and a little bit to the question, where you start to see more emphasis on what's often referred to as professional formation. Right. So we, in particular, over the last, I don't know, 6, 7, 8 years have really, you know, from the moment our students walk in the building, started to emphasize to them that they're joining a profession, right? And that there are certain expectations that come with that. And you know, to a certain degree, certain habits of mind that come with that, right? In addition to all the various ethical obligations and so forth. I think too, you know, just being more mindful of it. It's certainly the sort of thing that I individually in my classes do try to emphasize. You know, in terms of the actual concrete work, there are people. You know, it's an interesting combination of folks who are looking into, first, what is it? What does it mean to say somebody has good judgment, and how might we try to develop it? And that work is in its very early stages. A lot of interdisciplinary work being done by this sort of combination of psychologists and philosophers, because I do think it's, you know, it's ultimately, these are habits of mind that we're trying to instill. So, you know, in part the answer to that, in large part the answer to that is, you know, is really a to be determined. But I think recognizing it as something that we need to maybe think more about prioritizing is step number one.
Thank you. Professor Yablon or Attorney Mandell, would you like to chime in?
I don't have it's a great question. I don't have a great answer. I'll offer one anecdote from my own teaching. I have started in my upper level classes doing an exercise with my students that I call "You Be the Judge." And I give them briefs in an actual case that's relevant to topics that we're covering. And I do this a couple times a semester, and they have to digest the briefs. They have to write up a sort of summary of how they would rule in the case. And then we have kind of a discussion about it in class time, where I'll really push students who came down on both sides and try to, the idea is to get them to kind of develop this frame of mind that they really are taking seriously counter arguments, and that they're really forcing themselves to engage more deeply with positions that they might not have fully considered. So I don't know that that's making a huge difference in the world in terms of having students develop good judgment, but I hope maybe at the margins it does something.
And I guess if I can leap back in, I'll go with you know, I think part of the problem is that experience is a big ingredient of good judgment, and you know, you can't fully appreciate it until you've lived and seen how things play out in the world. And you know, one of the dangers that you know, it's the classic, you know, the new lawyer, right? They've got a hammer, and so every problem is a nail type situation. And you know, we tend in law schools, and I think, you know, particularly talented law students in law schools tend to be drawn towards abstraction and theory. And, you know, for me in particular, right, as somebody who came out of law school very much enamored of those sorts of things, very much thinking I wanted to do the job I'm fortunate to be able to do now, you know, coming into practice was really this experience of learning that, okay, there's a lot more going on in the context of any given situation that we have to deal with as lawyers. And, you know, you can't really teach that in a classroom. You can try to prime people to detect it when they're out there and to look for it and to know that it's coming. But a lot of it, you know, I just sort of feel I often, you know, tell my students increasingly, like, I feel like I'm an old man yelling at clouds right now, but, you know, trust me, one day you're going to be middle-aged and you're going to be sitting around a beer with your friends talking about, man, if I only knew then what I knew now.
I just might add that when I was a law clerk in one of our Court of Appeals, I was writing the opinions. Same thing that you talked about earlier. So go ahead, Kathy.
We actually have a question about law clerks writing opinions from Janie, and she asks, are law clerks chosen by the entire body or by individual justices or in some other manner? If chosen by individual justices, they might be chosen based on their ideologies. It seems as though law clerks could have a lot of influence over judicial opinions. Typically, how many law clerks are working in the Wisconsin Supreme Court at one time?
So yes, I mean, it is a very real concern that because it is mostly the case that law clerks are hired by individual judges and justices, and there is an increasing sense that more of them are aware of ideology in their hiring, right? That there's really kind of the, you know, two tracks, right? That if you're looking for a clerkship with a conservative judge or justice, you better be a Federalist Society member, and so on and so forth. Not all of them, because it is an individual decision, but certainly that does seem to be on the rise. And which is not to say it hasn't been true for a long time. That was certainly back when I was a law student applying for clerkships, something that we were aware of then as well. But it does seem to be more prevalent. And so yes, that, you know, that sort of compounds, I think, the potential echo chamber effect that we have. I think the Wisconsin Supreme Court justices have one law clerk each, but I'm not completely certain of that.
I think they generally two at a time each, but I too am not certain. I've never worked in that building, but I believe that each of the 7 justices has 2 clerks and a, you know, a legal assistant or a secretary at a time.
Okay.
And
Thank you.
it might vary a bit, actually, just depending on how they want to do their staffing. There may be some who only do have one, or who have someone who's in a more combined, like, clerk / administrative role. I'll say that actually our state Supreme Court is fairly leanly staffed if you compare, their clerk support to what federal judges get. Federal appellate court judges and the U.S. Supreme Court justices, they'll have 4 clerks. And so to, do the work that they do with just 1 or 2, I think that the justices on our court and in the federal courts, they are still playing a very real role in the drafting process. And so, although I don't disagree with some of what Chad is saying, I do think it can be overstated. I know in my own experience, yes, I worked on some opinion drafting, but the final product was very much the judge's product. And I don't know really how much influence I was exerting on that final product. I think that there may be situations in which some judges maybe are more careful and engaged than others. Some judges or justices may have career law clerks who over time take on a little bit more authority. But in my experience, with my bosses, they were very much deeply involved in the drafting of the opinions.
You. There's one more question from Dorothy. I'm going to combine it with she actually just submitted a second question. Are there particular aspects of the Wisconsin Constitution that are notably vague or poorly written and thus open up controversies? Can the Wisconsin Supreme Court or lower courts call in outside experts of any kind to help examine elements of fact or history?
I'm happy to jump in. I mean, I think that there are parts of the provisions in the Wisconsin Constitution that are definitely vague. And there are definitely some that are probably not written with ideal precision. Part of that is in the nature of a constitution. It's not like a statute or a regulation that is trying to deal with every possible situation. Some of it's about the fact that, this is a document, large parts of which are 170 years old, 175, so there are a bunch of things that go into that. And yes, the Wisconsin Supreme Court in particular, other courts, lower courts in Wisconsin as well, can call in experts. They usually call them special masters or referees to deal with elements of fact or history. We saw that in the redistricting case in 2023, where the court took it upon itself to hire 2 experts in political map making and have them evaluate the various maps that the different parties in the case submitted, and then simply took the bill that the experts submitted at the end for their time, divided it among the parties, and told us to pay it. So there is that possibility. I will note, and Rob or Chad might have things to add or see it differently. One of the challenges we have with the history piece here in Wisconsin, and I think a challenge with originalism, and for those who profess to care about original intent with the Wisconsin Constitution, is we don't have particularly great sources and resources about exactly what happened at the state constitutional conventions and what people were thinking or what varying proposals were. Mostly what we have are collections of contemporaneous newspaper editorials from around the state, but we don't have particularly good minutes or notes or records from the constitutional conventions themselves. Keep in mind, we had 2 constitutional conventions in Wisconsin, because the first one, the Constitution failed ratification, and then the second one, the Constitution passed. And it makes things really challenging at times if you want to try to dive into that history.
Yeah, I'll just add a couple thoughts on that. I mean, the fact that Wisconsin's constitution is, parts of it very old, and Wisconsin is one of the fairly small number of states that still has its original constitution, which is kind of an interesting thing. And so it's accumulated parts over time. And I recall, for example, when Justice Protasiewicz was first joining the court, there was the whole question of whether she was going to be impeached if she didn't recuse herself in certain situations, and trying to figure out how the impeachment portion of the Constitution, and I'm not remembering the name of the other mechanism that exists for removing justice, but these 2 things that didn't really mesh together perfectly well. So you have instances like that. You've got things like the rights provisions, which are intentionally vague. You've got the fact that the state constitution, like many of them, is in some places pieced together with parts that are copied from other state constitutions. And, what do we do with that in terms of trying to figure out what the original understanding was? There's a lot of complex pieces to the puzzle.
Let me just say briefly, although this is a very informed and engaged audience, I suspect that many folks in this audience have never even really taken a close look at the Wisconsin Constitution, and knowledge of state constitutions is just significantly less than the knowledge that we have of the U.S. Constitution. Part of what my colleagues and I do at the State Democracy Research Initiative is to try to get people more engaged with state constitutions, and so this is just a slight bit of promotion, but I'll put this in the chat. We have a website called 50constitutions.org. And we've, at this website, put together the text of every state constitution. And I've given you the link to Wisconsin in particular, but we're also building out state by state information about Wisconsin's constitutional history, the constitutional history of other states, some of the resources that are out there, although as Jeff said, they really are incomplete resources. But you can do some searching. You can see how the Constitution has changed over time. The Wisconsin Constitution has been amended over 150 times in the last 175 years. And so if you want to do a little bit of exploring on our own constitutional history and text, there it is. And you can do some searching and comparison with other states as well.
Okay, thank you. I think we're at a close. If we had more knowledge of the Wisconsin Constitution, we might understand all the constitutional amendments that are deluging our government as well. So that's something we can do for another day. Thank you. Thank you to our great experts who've contributed so much information about our Wisconsin Supreme Court and the election cycle that's ahead of us for the next 4 weeks. Hopefully, with this background, we're fully aware of what the voters need to look for from Judge Crawford and Judge Schimel as they each run for a seat on the highest position in our courts. Historically, this is a low turnout election, so it's imperative to contact everyone by social media or in person to make sure they're registered and will vote. Clearly, the stakes in this state Supreme Court election could not be any higher. The outcome of this election is in our hands. Please check the league website in a few days for the recording of this webinar and forward it to anyone who missed our presentation tonight. Thank you so much for attending the league's webinar tonight. Good night. Thank you. Thank you, everybody. Good night.